Hi class, this is Omar and I form part of Team B. Today I will not be in class due to work engagement. I'm located out here in Baltimore, Maryland, where the weather is in the 60s, so a little chilly outside. Today I'll be presenting two case scenarios, case scenario C, which is Jeff, and case scenario F, which is Jason. In the first case scenario, at the end of summer, Jeff had earned enough money for a down payment on a car. He decided to continue working part-time during school to earn money for the car payments. Jeff purchased a car from Steve at a local used car lot. Steve did not ask Jeff his age, but assumed he had reached the age of majority. Jeff paid the down payment and signed the contract stating that he would make payments of $200 each month. Now, 6 months later, Jeff lost his job and could no longer make the payments. Jeff returned the car to Steve and said he wanted to cancel the contract and that he wanted his money back. So, in this first case scenario, you find several issues or several questions that can arise from this. The first one is should Steve, return the money back to Jeff? And then does Steve have any valuable defenses against Jeff? And does Jeff, vice versa, have any valuable defenses against Steve? Who will be more liable for any monetary payments? So you can apply several rules here. The first one, of course, Steve, as a seller of a vehicle, he made an assumption of Jeff's age, which is definitely what we call scienter. He should have obtained proper verification or identification before releasing, of course, the vehicle to Jeff. Now, in the doctrine of mutual assent, there was definitely a meeting of the minds and it does mention in the case scenario that Jeff paid down and signed the contract stating that he would make payments of $200. So there was definitely something that was voluntarily, knowingly, and willingly in this case scenario. In addition, Jeff can also argue that there was strict liability and negligence. Jeff will state that Steve failed to verify and to fulfill his duty of care since he was never asked for proper identification. Also, Jeff will defend himself and say it was assumption of risk, which Steve knew the conditions of the terms and voluntarily expose himself for a financial gain. So, based on the first case scenario, the court will find a reasonable person and test likely that Steve, for negligence due to his breach of duty and his carelessness in not verifying Jeff's age. This would make the contract also voidable by Jeff due to his age or by the minor's guardians. And the second case scenario, which is Jason, which is case scenario F. In this case scenario, you have several parties involved. And in the case scenario goes, Jason shipped a truckload of peaches from his orchard to Grocery Incorporation using an independent trucker. En route, the truck broke down and the shipment was delayed 3 days. The peaches were spoiled when they arrived. The terms of the contract were FOB. Now, in this case scenario, there's no contract or no disclosures or no conditions. Nevertheless, according to the book using the UCC, the Uniform Commercial Code, which is found in Chapter 1, it provides a comprehensive set of rules and principles intended to increase reliability and predictability in business transaction. Now, these rules and principles were designed to determine who would bear the risk of loss in dealing with a contract or a custom. Now, the term FOB in this case, which is a shipment contract, refers to free on board or point of origin. This will normally place the risk of loss plus shipping and loading costs at the FOB point, which is usually the seller, the factory, or the warehouse onto the actual buyer. Now, the independent contractor can also assume the risk to Jason for negligent hiring since in this case scenario, it does not talk about the background or the history of the independent trucker. Now, on the other hand, the independent trucker may also be liable to an extent since the goods were spoiled, and of course the shipment was delayed. However, under the assumption of risk and liability as an independent contractor, An equally important factor is that the principal, in this case Jason, generally has no liability for actions and omissions on behalf of an independent contractor. So as a result, lastly, the party was waiting for the shipment to pursue to. He was waiting for the shipment, so he will file deep pockets recovery and extend liability to as many applicable parties, and will file respondeat superior since it was under the course and the scope of employment.